419 Jalecia Grant versus Davian Grant. The respondent is not present. The petitioner is present. The attorney for the petitioner is present, and there is an attorney present who represented the respondent at the initial TPO hearing back on August 9th of 2022. The order expired under the law yesterday. The court has received a motion to withdraw, although the attorney indicates he was only retained for the initial temporary protective order hearing from the respondent's attorney. And from the petitioner's pleadings, there is a pending divorce and under a separate case number, and the respondent may have a different attorney in that case. The petitioner's attorney filed yesterday, on the day the order expired, a motion to be heard on this hearing. And he cited the Wynn case for notice, although the Wynn case is a bit different posture in that circuit than we are in this case. So let me just say this. I have some concerns on proceeding on any motions with the order being expired as it now stands, in that any hearing I had without the respondent present and having not been served could be considered ex parte proceedings.
Your Honor, if I could briefly address my presence, it would be
okay. I'll do that first.
Yes,
all right. So go ahead.
It would be my position that I'm here in my personal capacity. My prior client has dismissed me as his attorney. I can cite some law for you that once I've been dismissed or discharged as counsel, I have no rights or powers over the case. The case was closed on the online docket. I was unaware of any of this action that was occurring. I see it looks like about 20 actions had been taken in the last 6 months. My first notice of anything occurring was when the court got in touch with me on Thursday of last week. I immediately contacted the court. I reached out to my client. I was able to get him where he confirmed with me that he did not want me present, or he did not want me to represent him. And that he had another attorney that he was speaking with. From that point, I haven't been able to reach him at that point, but after that conversation, I filed my motion with the court to withdraw, and it would be our position that, or my position personally, that I no longer have an ability to represent him legally because he has made it clear, and via my motion, I made it clear to both the court and the petitioner in this case that I do not represent him in any legal capacity at this point in this case.
Okay. Mr. Meacham, do you have any response on that?
Yeah, Your Honor, may I be heard on the motion that we filed and bring?
Well, let me ask about this first on his attorney. On his attorney, whether you think, do you have anything about what the attorney has said about him not representing the respondent?
Yes, Your Honor, and I would cite Georgia Ethics Rule 1.3, and it says, it's entitled diligence, and I'll incorporate that with the motion to withdraw. It says that a lawyer shall act with reasonable diligence and promptness in representing a client. Reasonably diligence, as used in the rule, means that an attorney shall not, without just cause to the detriment of the client, in effect, willfully abandon or willfully disregard a legal matter entrusted to the lawyer. If you look at counsel's motion to withdraw, he says he represented the defendant in the initial temporary protective order hearing on August 9th, 2022. And this was before you, Your Honor. So it's good to see you again. However, counsel has had no involvement in the case since the hearing. He said neither counsel nor respondent received notice or copies of these pleadings. Now, logically speaking, if counsel says and represents to the court that his client has not received notice, then he has spoken to the client about this hearing. It's just factually impossible for him to speak on the absence of notice of his client without being told from his client that he hasn't had notice. Additionally, until August 3rd, 2023, counsel has never been advised of any hearing. In paragraph 4, he said, while it appears that a hearing is set for the case, proper service and notice has not yet been provided to the respondent. Most importantly, respondent has yet to be provided a copy of the motion. Once again, Your Honor, the court, for due process purposes, talks about notice. counsel has an ethical obligation to inform this client whether he has withdrawn or not, because the court has not ordered the withdrawal of any pending legal matters. And that's, I just read to you what the ethics rules 1.3 provides. So this is a case of hiding the football, if you will. The case in Ford says that to comport with due process, and let me cite Ford for you, Your Honor. It's a Supreme Court case, and it's found at 270 Georgia 314. And it says in pertinent part, to comport with due process, notice must be reasonably calculated under all circumstances to apprise interested parties of the pendency of action and afford them an opportunity to present their objections. Your Honor, without getting into our argument about notice, because the court just wants me to respond to counsel's representation, I think that has been satisfied.
Okay, so a lot of times, so let me ask this to the respondent's potential former attorney. What were you retained? What was the agreement of your retention?
I was retained to handle his temporary protective hearing that was scheduled for August 8th of 2022.
Okay.
After
So we
that,
often have cases that end up on the motions calendar and the attorneys no longer represent the clients because they were initially retained for that initial hearing.
Can I respond very briefly, Your Honor?
Yes, go ahead, please do.
So first, on the diligence point, I would present to this court that I have used my 100% of my ability to be diligent in this case. As soon as I got any information about anything being done, that was August 3rd of this year on Thursday, I contacted my client. I believe Mr. Meacham must have misheard what I said initially. I did speak to him that day. I called him as soon as I got it. I spoke to him and I asked him what was going on. I understood there was a divorce that was pending from last year. And he advised me that he had an attorney on the divorce and that he was going to speak to that attorney. I gave him my opinion on how what we could do, and he said he would talk to his attorney about it and get back to me. He made it very clear to me that he did not want me to represent him on this case. I then contacted the court and I filed the withdrawal. So I just want to make clear, I did speak to my client on Thursday. So when I represented that he didn't receive notice, I'd been told that. I can't speak to that, but I can speak to myself. Mr. Meacham's office has filed several motions in the case. It was not until the most recent notice that I was served by email and the certificate was attached. He did provide me subsequently, after I filed the withdrawal, an email copy of two prior motions filed, the motion for the permanent order and the motion for contempt. Of note, there is no certificate of service attached. I never received any service on those cases.
Were you previously served with the motion from earlier this year?
No, Your Honor. That is my point. The first contact I ever had on this case since Your Honor issued the permanent order was on Thursday of last week, at which point I entered the withdrawal, and it's our position that at that point, once it's become clear to the court and to the petitioner that the respondent has disposed of me as his attorney, I can no longer serve in any capacity to represent him.
You remember?
And just to be, if I could finish, the only reason I am here is as an officer of the court. The court has provided me notice to be here, and I'm here in my personal capacity.
Okay. And was that from, I didn't have the previous calendar. Is that from court the last hearing?
I believe there appears
Mr.
to
Meacham?
have been.
Your Honor, there's only been one motion that we filed. I don't know how counsel is saying that there's been 9.
Well, I mean, no, hold on. No, I'm
There's only
asking, this
been one
case was
motion that we
continued
filed.
to today from,
It was continued from July 26th to August the 3rd, and it was continued from August the 3rd to today.
okay, so let me ask this. When they continued it to today, what was the purpose of the continuance?
For us to present evidence of all of our efforts on giving him notice of this proceeding and any other diligence that we've dealt with. You're the third judge, Your Honor, that we've dealt with on this case. The first judge.
I understand. And let me be clear. I'm just trying to figure out legally, someone may know about a hearing and know of a hearing, but that's different than notice. And I'm trying to see if there's not exception for evasion like there is within the 30-day rule where you can get 30 days extended. You know, we're past that at this point. And the divorce case is a separate case from this case. So I've had attorneys make special appearances saying that they're appearing because this person has not been served. And has anyone attempted the sheriff? There's no sheriff's department service at all at this point?
We hired special process service, Your Honor. And in fact, let me just address the divorce. The divorce.
Okay, so wait, let me get to one point. So I don't think, from what's been presented to me, Mr. Kozicki does not represent the respondent at this point. He has stated as an officer of the court that he does not.
We contacted his attorney who represents him in the divorce, named Ruby Knight.
Mm-hmm.
Mr. Kozicki says that his former client said that he's being represented in this matter by Ms. Knight. When we contacted Ms. Knight, and as an officer of the court, I will confirm and attest to this. She said that she has only been hired by Mr. Grant to represent him in the divorce. She is not representing him in this.
So that would indicate at this point, I'm left with him being pro se in this matter at this point.
Well, I'm just addressing what he said. He said that his client said that his attorney was representing him in this matter, as well as the divorce. And I'm saying that she said to me, she's only representing him in the divorce and not this matter.
But what I'm saying is we have Mr. Kozicki is here, and so the client didn't say Mr. Kozicki is representing him. Mr. Kozicki said he's not representing him and has not been retained for this. So it sounds like Mr. Kozicki is out of it. And what is happening is if he's not represented by the divorce attorney, then he's pro se at this point, as far as all parties are aware.
Yes, Your Honor, but I think that we'd like to be heard on the issue of notice because
that's what. So I wanted to get this first. If we agree that the respondent is pro se at this point, or represented by the divorce attorney, who you say from a conversation that he's not,
I will take Mr.
Kozicki is not.
I will take Mr. Kozicki's word that he's only representing him in the first matter, that the client has indicated to him that he does not want his representation in this matter. And therefore, because he's been released from the client and the divorce attorney is saying she's not representing him on this matter, then it would be ipso facto that he is pro se.
Yeah, I mean, I think that's what I'm left at. I was trying to distinguish that before I heard anything else. So, all right. So, Mr. Kozicki, thank you for being here. I apologize if I'm mispronouncing your name.
No, you got it right.
Okay. So I don't know if you're not retained that an order of withdrawal needs to be filed. If you're not representing him, but I can sign that. Although the order's expired at this point. And I know we're going to get to that, and I hear you, and I know where you're going, Mr. Meacham, and I'm going to give you a chance to have that, to lay that out for me. And I am very familiar with that case and the law on that. So I am going to, I'll sign that order of withdrawal, and you are excused.
Thank you, Your Honor. I appreciate your time this morning.
All right, thank you. Okay. All right, so Mr. Meacham, you have filed a motion to be heard. Because the order is expired, like I said, but I understand what the argument you are making. I'm treading very carefully because I do not want to proceed pro se without having had notice and an opportunity to be heard for the respondent. And I understand. So I will hear you on the motion you filed yesterday. And then we will go from there.
Your Honor, presently before the court is the petition to proceed to the hearing for a permanent protective order on the issue of notice, petitioner's motion for contempt, and petitioner's motion for a permanent protective order. We were before the court last Wednesday, August the 3rd, and prior to that, Wednesday, July 26th on this matter, and informed the court that although the respondent in this matter had not been served as a result of his deliberative orders, he had received notice on this matter and a hearing. At the conclusion of the hearing on the 26th, Judge Guy, I think was her name, reset the matter and said that I understand what the respondent is doing. I want you to evidence to me all the diligence that you've employed to serve him, and I will address that issue at the next hearing. Well, the next hearing was August the 3rd. She was not present on August the 3rd, and that judge said because Judge Guy was familiar with this, and he understood that I had a non-protonc argument as relates to it expiring with the next set date. He would set the next date and the court would inform me of that date, which was today. Prior to July 26th hearing, we hired two different private process serving companies, ABC Legal and Anderson Process Service, to serve the respondent with notice of these matters. Both companies collectively went out to the respondent's resident and attempted service on 7 different occasions. However, upon their arrival at the respondent's home, no one would answer the door despite there being active movement in the house and continuous peering out of the window. We had each process server prepare an affidavit as the petitioners exhibit 1 and 2, and would like them to be admitted for the court for your consideration. Yeah, my office just informed me, Your Honor, that the expiration of the initial order expires today, not yesterday.
No, it was issued today. It was issued on August 9th of
Okay.
2022, so it expires on August 8th of 2023.
All right, I would direct the court's attention to Exhibit 2 of the affidavit. Paragraph 3, Your Honor, it says that I'm the owner and founder of Anderson Process Service, and I've been an appointed process server for over 20 years. I'm currently appointed to service the counties of Forsyth, Fulton County, Gwinnett, DeKalb County. Paragraph 4 said I was initially hired by Jaleesa Grant in or around January of 2023 to serve Mr. Davion Grant with legal documents at 0038 address. Upon my arrival, an older lady answered the door and accepted the service of the documents. She indicated that she was Mr. Grant's aunt and that he was a resident at her home. Paragraph 5, page 3 states, on July 22nd, 2023, I was rehired to serve additional legal documents to Mr. Davion Grant at 32 address. Upon my arrival, no one answered the door. Instead, I observed movement at the front door window, blinds, and a FedEx package displaying Mr. Grant's name laying on the front porch. On July 24, 2023, I returned to the address of 32 Mr. Davion Grant with legal documents. Again, no one answered the door. However, I did observe individuals peering out the front window blind. On July 26, 2023, I received additional documentation to serve Mr. Grant concerning a new court date. I returned to the address of Mr. Davion Grant with the legal documents. Upon my arrival, a teenager, African-American female, approximately 13 to 15 years of age, answered the door and advised that she did not know anyone by that name of Davion Grant. Paragraph 8, page 4 states, I then contacted Ms. Jaleesa Grant regarding this encounter. Ms. Grant sent me a picture of Mr. Grant's daughter inquiring if the young lady was the same person who answered the door. Upon reviewing the photograph, I was able to confirm that the young lady in the photograph was in fact the same teenage African-American female who denied knowing Mr. Grant. Number 9 says it's my professional opinion that Mr. Grant is a resident and has purposely and deliberately avoided service. Directing the court's attention to Exhibit 3, proof of delivery of a FedEx package sent by my office to that same address, delivered on July 22nd, 2023 at 10:58. We will move the admission of both Exhibit 2 and Exhibit 3 into evidence, Your Honor, for consideration of this motion.
Okay, they're admitted.
Since the July 26th hearing and in preparation for the August 3rd hearing, we again employed the services of Anderson Process Service to effectuate service on the respondent. On July 26, 2023, Mr. Anderson returned to the respondent's home and attempted service to the respondent without notice of these matters. However, once again, service was not perfected because the respondent's daughter answered the door, which I just described. During the August 3rd hearing, we presented the matter before Judge Foxworth, could not remember his name, advising that the respondent was again deliberately avoiding service and that Your Honor indicated, meaning Your Honor, Judge Guy indicated that at the last hearing that she would take all of these diligence into consideration and make a determination at that time. And she understood what she was under the impression that Mr. Grant was doing. Believing that the court could not proceed beyond the expiration of the 12-month order, we presented the precedent to Judge Foxworth, presented precedent to Judge Foxworth, showing that the court had the discretion to proceed with the matter beyond expiration of the 12-month order when the petitioner timely filed the petition for a permanent order and the respondent received notice of the petition. citing Nugent versus Ding, and I'm mispronouncing the last name.
Yeah, and I'll tell you, my one concern about that case is that it sounds like the permanent order request was filed in the divorce case where he was represented, and there was a hearing held with him and his attorney present. So that's the one distinguishing factor that gives me some pause, but continue. I am familiar with that case though. Thank you.
We also provided case law from Georgia Supreme Court showing that the court could issue a non-proton permanent order after a hearing is held when the petition was timely filed and the respondent received notice of the matter and a hearing was held after citing Nugent, as well as Duggan, I think is the pronunciation.
Yeah, I both of those cases I'm familiar with. I
I
think Duggan, they started a hearing and then had to finish it afterwards. I have a question. When you say you've served you provided the motion to the divorce attorney, do you have any evidence of that?
No, Your Honor, what I simply did is this. I called up and I asked her, would she accept service on behalf of her client? Her name is Ruby Knight. And if the court has any issues about my credibility, they're free to call her up. She said that she was not hired by Mr. Grant to represent him in this matter, and that she would not accept service on his behalf for this matter. In other words, Your Honor, other than me driving over to Mr. Grant's house myself, and I don't think that I'm licensed as a process server to serve him, we have employed every possibility of giving notice. And if you allow me to continue, we even sent an email from a Gmail account because we did want him to not answer it because he saw it was the firm. And we have evidence, and I'll get to that evidence, that he accepted, he reviewed it, read it, and knew of this hearing. Since last week's hearing, we again employed the assistance of private process server to physically serve the respondent. We overnighted the documents again through Federal Express, and that is in P13. And let me ask Madam Clerk to pull up P13 that's attached to this motion. What?
And has anything anything been filed in the divorce case noting evasion of service in this case?
No. This is a Gmail account, and the Gmail account evidences the fact that he opened this email, and the email reads in pertinent part, "Good afternoon."
Okay.
Good afternoon, Mr. Grant. As you're aware, our firm represents the petition above.
Hello.
Ma'am?
Hello.
Yes.
One moment, sir.
I'm sorry.
Go ahead. Somebody pop back in.
Okay. As you're aware, our firm represents the petitioner in the above referenced matter. Please accept this correspondence as notice that the petitioner has filed a motion for contempt and a motion for permanent protective order in the above referenced matter. Please be advised that there is a hearing scheduled tomorrow morning at 9 a.m. in the above referenced matter. This hearing will be conducted via Zoom, and then they gave the credentials for the Zoom. Exhibit 12, email motion to Mr. Grant. And it says the same information that Exhibit 11 did. The hearing notice and the Zoom meeting credentials in the body of the email to the respondent directly to each of his 2 business emails accounts, as well as his 2 personal accounts with the red receipt and delivery tracking engaged. We later received a confirmation and email receipt indicating that the respondent not only received the email at each account, he also opened each email and attachment for all 4 email accounts. And that's pages 2, 3, and 4 of the exhibits.
Okay. How do you know what he opened and didn't open?
Because of page 2, 3, and 4 of Exhibit 11. If you look at the page 3, it says tracking event, Your Honor, and this is, Madam Clerk, this is Exhibit 11. And I'm directing the court's attention to page 3 particularly. It says to the left, Your Honor, recipient opened, recipient opened, recipient opened, recipient opened. He opened it, and it gives the times, and it gives the client device. At this point, we have gone through great lengths to not only physically serve the respondent, but we've also gone through great lengths to give the respondent notice of the matter and hearing. And we can confirm that he did receive actual and legal notice of this hearing at least yesterday on August the 8th, 2023 at 2:43 p.m., 2:58 p.m., 3:03 p.m., 3:08 p.m., and 3:17 p.m. as
And that
identified.
you're saying that's via email, assuming he's the one who logged into email and opened the attachments.
Where the petitioner can testify to his email address if the court has any concerns about whether or not this is his actual email address.
And now I'm just, yeah, we're assuming that even if that is his email address, that he's the one who opened the emails and looked at them.
Yes, Your Honor.
And I understand. I'm just trying to, okay.
Despite all the efforts of service and having been deliberately avoided by the respondent, I think that the petitioner, as well as the counsel for petitioner, has made every good faith effort to satisfy the due process clause as required in notice to a party, an interested party. Your Honor, we can't, if a party is making an asserted effort in a circular argument, and this is the circular argument. Mr. Kaczynski is saying that he's no longer representing the client, but he also told the client of the notice of the hearing. So he, as the former attorney, because he's still attorney until the court signs off on the order for him to withdraw, he's made his client aware of the notice. The process server, having served him at his house before, was told by the daughter that she didn't know who he was, and when that daughter is identified in a picture by her mother, he identified her as being the child who said she didn't know who that was. So, you know, I'll just.
So I think, so here's the thing. I don't think there's any, well, first of all, we always tell people to try to file their motions for permanent orders a couple of months before it expires to give you time, because unfortunately evasion of service is not uncommon in some of these cases. The question before the court, what you've provided is not necessarily actual notice, but is evasion of service.
I think Taylor talks
qualify
about
as notice.
I think Taylor talks about reasonable notice. It does not talk about actual notice. Taylor versus Hayes, which is found at 418 US 488, and Dowdy versus Palmore, found at 251 Georgia 135, talks about reasonable notice of a charge.
Are those TPO cases? Are those protective order cases?
Yes, Your Honor. These are cases that says that a party has an opportunity to be heard in defense before punishment is imposed. So it probably more is a criminal matter than a protective order matter. Nonetheless, due process and notice is due process and notice, whatever the matter may be, whether it be civil or criminal, or in this particular matter, for protective order. And it says, to comport with due process, notice must be reasonably calculated under all the circumstances to apprise interested parties of the pendency of an action and afford them an opportunity to present their objection. The notice must be of such a nature as reasonably to convey the required information. The required information is both emailed, FedExed, told by the former attorney. I think that.
Well, he said that he told him there was a court date. He didn't say he provided him with the pleadings.
Well,
and I haven't made my decision yet, but hey, if I have to make a decision on legal, and is this legal notice we can go forward on, I'm making that decision on the law.
Your Honor, you have always been fair with us, and when I laugh, it is not laughing at what you're saying. It's just
I see the circle, just like Judge Guy said. I see it. Does the law have a remedy in this situation? And that's what I have to look at. Did anybody send a certified mail to him? I know you did FedEx.
No, we did FedEx, Your Honor, because we sent a FedEx on Monday that asked for a signature and was told, as the daughter said, he doesn't live there. Or she said she didn't know him. So now he doesn't live there. So, I mean,
Okay.
Your Honor, I don't know. I don't know anything else that we could have done as relates to, if we'd have started this process Christmas of last year, this man has that, Your Honor, he's the same person that told you this woman hit him in the head and in the eyes when he then confessed he had allergies, and that's why his eyes was red. His credibility is of no moment.
So I understand. I just, we have cases where people spend attempts private process servers 15 times before they get service. Somebody sits on their house until they walk out the door to walk the dog or do something. So this isn't a case necessarily of first impression. It's just, it's coming up at a time, being heard at a time when the order has technically run. And I have to decide if legally there has been sufficient notice for me to have the hearing.
I mean, I guess in the alternative, Your Honor, I think there's been sufficient diligence to extend the order. And I think that's kind of the same thing, I think that when we just heard this back before Judge Fockworth, he was saying that obviously my argument was about a non-protunct in enforcement of the temporary, and we made that argument then. He passed it on to you today, but that's not because of it's not for lack of our making the argument. It's not lack of our petition to do it. It's not lack of any presentation of evidence to support it. So I don't think that my client should be disadvantaged because of it being heard by 3 different judges and being scheduled 3 different times, one time beyond the time of yesterday, when we have made all the efforts in order to satisfy.
I understand it was scheduled for no service, and to provide evidence thereof.
We did that. We provided evidence on the 26th.
I'm going to decide if there's been evidence of notice. That's the decision I'm making, right?
I don't like it when you pull your glasses off your face and put them back, Your Honor.
I'm going to have to look at some of the cases you quoted me. I'm going to have to look at. So what I'm going to do is this, because it is though past the time, if there has not been service and I issue an order saying so, obviously she would need to refile and go through the process again if she felt she still needed an order of protection. If I find it has been reasonable service, then I would be able to hear any evidence about why any contemptuous or extension of the order. So I'm going to need to look at the law again and review it to give me some, because like I said, it goes both ways, right? There's not necessarily an evasion of service exception for extension of a 12-month order. But if there has been notice, because people evade service all the time. Yeah, but if there has been notice, then I may be able to extend it non-proton.
And I think, Your Honor, there is a slight distinction between notice and service. He's been on notice of the hearing. And due process says that if a party is on notice and has had the opportunity or will have the opportunity to object or not object, then due process is satisfied. We're arguing.
And it's also noticed, but the part of that is the contents of the pleadings against him is what he has to have notice of.
And that was satisfied, Your Honor, in the email that it said that he read and accepted. It was also in the FedEx package that he got that said, and if you look at the affidavit of one of the process servers, the affidavit says that one time he came there was a FedEx package on the porch. When he went back there, that FedEx package was no longer there. Now you could assume, I guess it could be argued that the dog took it off the porch.
Well, or you could end up with notorious service. So a neighbor, or the wife gets it, or not the wife. I'm sorry, that would be bad.
The wife is on
and opens it, right? So the daughter, I know. The daughter gets it, opens it, throws it in the trash.
Well, the daughter said that she didn't know who this man was, even though
I know, but you hear what I'm saying. I mean, so here's what I'm gonna do. I'm gonna let y'all, because I'm gonna need some time to look at this, but then I don't want to bring everyone back in if I decide there has been notice to have an extension. So I'm gonna let you present on the
contempt.
contempt and the
permanency?
extension.
Yes, ma'am.
Then if I don't find, then obviously I won't be able to extend it. And y'all will have to take up a remedy either in the divorce case or with a new TPO. Okay.
Yes, ma'am.
All right. So you may call and swear your first witness.
You have filed a motion for contempt and motion for permanent protective order. Is that correct?
Yes, sir.
I'd like to show you what has been marked, and Madam Clerk, pull up Exhibit 4 for identification purposes. And that is the family violence 12-month protective order signed by Judge Davis on August the 9th, 2022.
And I can take judicial notice of that order. It's already part of the record.
Okay. Do you recognize this document?
Yes, sir.
And is this document a true and accurate copy of the 12-month family violence protective order, which was issued by the court on August the 9th, 2022?
Yes, sir.
And Your Honor, I guess we don't have to move the admission of it since it is a pleading, but we just do it just for the court to.
That's fine. I'll admit it.
Directing your attention to page 2, paragraph 12. Do you see that document on the screen?
Yes, sir.
And does that paragraph 12 state that the respondent is ordered to have not have any contact, direct or indirect, through any other person with petitioner by telephone, fax, email, or any other means of communication except as specified by the court order?
Yes, sir.
And upon receiving and reviewing this order specifically, was it your understanding that respondent is prohibited from communicating with you either directly or indirectly?
Yes, sir.
Directing your attention to page 4, paragraph 19 of this order. Can you please read that paragraph? And I'll read it aloud. It says the respondent, both respondent and petitioner, are ordered not to connect or have disconnected home utilities, change or have changed, and or cancel or have canceled auto, health, or life insurance for respondent, petitioner, and or petitioner's children, or interfere with respondents, petitioners, and or petitioner's children, children's mail. Do you understand paragraph 19 as a prohibition against the respondent from canceling any of the household utilities?
Yes, sir.
Did the respondents cancel any of utilities?
Yes, he canceled the cable, internet, and car insurance.
And I want to show you what has been marked as Petitioners Exhibit 5, Madam Clerk, and directing your attention to page 2 of that document. Do you recognize this document?
Yes, sir.
Is this a true and accurate copy of your car insurance and cancellation notice?
Yes, sir.
And was Mr. David Grant responsible for paying the car insurance?
Yes, sir.
I'd like to move Petitioners Exhibit 5 to be admitted in the evidence, Your Honor.
It's a minute.
Has the petitioner, since the entry of this order, made any threats towards you directly or indirectly?
Yes, sir.
And could you describe them for the court, please?
He's made several threats through social media posts, as well as he sent a package to my home.
I want to show you what has been marked as Plaintiff's Exhibit C for identification. And Madam Clerk, that's a social media post. At the top of it has 1023 and the name Raza Chain.
I do not see that one. Sorry.
You don't see it? Okay. Your Honor, may I read it to the court?
You may.
Okay. Exhibit C is entitled, it's a social media posting, has at the top of it Raza Chain, and I'll kind of show it so the court can see what I'm reading from. It has Raza Chain, and I'll ask our client, do you recognize this document?
Yes, I do, sir.
Is this a true and accurate depiction of the respondent's Facebook's no social media posts?
Yes, sir.
Is that a picture of him at the bottom of the page?
Yes, sir.
Okay, can you, Your Honor, you see this? I'm just kind of holding up to the screen.
Mm-hmm. What exhibit number is this?
Exhibit 6.
Okay.
Is he known on social media as Raza Chang?
Yes, sir.
I'd like to move the admission of Exhibit 6 in the evidence, Your Honor.
Okay, it's submitted.
And I'd like to read, since we're having a little bit of problems with pulling up, what the posting says. It
So
says,
this was let me ask this first. This was a post that he posted. Was she tagged? Does she follow him?
can you answer
Is she a
those
friend?
questions? Can you answer those questions that the judge just posed?
No, I do not. I was not tagged and I do not follow him.
So how did you become aware of it?
He follows my friend, my best friend, and that's how I was sent a screenshot of the post.
So your friend sent you a screenshot.
Yes.
Okay. All right,
They,
go ahead.
they use my past as a weapon to not face their insecurities. So what if I look serious? If you're intimidated, that's on you. Is it that fear causes you to feel intimidated? Yes, I'm aggressive, rough, and tough. That's my nature. Am I wrong to be? There's a big difference between common, educator, and common sense. And the fool's talking about you are a hitman. Do your homework, seen before you step. Don't let chatty mouths fool unknew. And that's spelled UNNUH. Raza Chang / Bomba / Mad Shark, etc. Never back from any challenge. When was this post sent to you, Ms. Grant?
November 2022.
And who sent it to you?
My best friend.
I want to show you what has been marked as petition exhibit 7. And Madam Clerk, this is Amazon customer service chat sheet. Is this a correct and accurate copy of a customer service chat transcript between you and Amazon?
Yes, sir.
And can you tell the court what initiated this document to be generated?
Yes, I received a package that I did not order. So when I inquired of where the order came from and who ordered it, Amazon disclosed that it came from Mr. Grant.
I'd like to move the admission of Exhibit 7, Your Honor.
All right, it's submitted without objection.
I'd like to show you what has been marked as Plaintiff's Exhibit 8 for identification. And Madam Clerk, this is another Facebook posting. That's it. Yes, ma'am. Thank you so much. Do you recognize this document?
Yes, sir.
Is this a true and accurate depiction of the respondents, Mr. Grant's Facebook social media post?
Yes, sir.
I'd like to move this petitioner's Exhibit 8 into evidence, Your Honor.
Okay, it's submitted. Now, just this, go ahead and, so these
And the
are
reason-
not, these are, how are you receiving these messages?
It's a screenshot from my same best friend.
So
that
your friend sees them.
followed.
So he's not calling you out by name, but he looks like he might be talking about you. And she screenshotted him, sent him to you.
Yes, because the posts are very direct he's talking about things directly related to us, the child support, my father.
And did you interpret Judge Davis's order of no contact being direct or indirect, meaning that he should not contact you directly or through any of your friends or relatives?
Yes,
Okay.
that's what I understand.
Directing your
What was the
attention,
date of that one?
6/13/23. Directing your attention to the top of the page of the social media, the handle Raza Chain. Do you recognize that as being the handle for Mr. Grant?
Yes.
And the respondent's social media handle is Raza Chain. Is
Yes.
that correct? And I'll read it for the court as opposed to asking the client to read this. It says, she finds every reason to talk about me. I'm convinced she is still in love with me. She's confused, bitter, and angry. She's asked for $3,400 in child support and got $600, which started 12/1/22. Now you're saying with not getting my money 10 months now, anybody who knows how child support works knows my driver's license would have been suspended and I travel every week. And a you man, a Wasta man, him have you thinking and talking about me every day. Your dad is a Wasta man. He never took care of you, and he have children in Ja, and he's here over 30 years and don't help no one on NT1 that's a Wasta man. Your emotions are still over the place. Get some help. You were once under my command. You had to do what I say. So I'm not bothered by your tantrum. You are a good mother. Keep it that way. You are no done. Go sit TF down. Did you interpret this posting as an insult or aggressiveness to you, Ms. Grant?
Yes, sir.
Prior to the entry of the 12-month order, was the respondent ever physically aggressive with you?
Yes, sir, he
Was
was.
he ever verbally abusive to you?
Yes, sir, he was.
Did he ever assault you?
Yes, he did.
After receiving this message, did you feel threatened by these statements?
Yes, sir, I do.
What is a wasta man?
It's Jamaican patois. It's a waste man. It's saying like somebody who is a bum or someone who doesn't handle their responsibilities.
Has the respondent made any other attempts to communicate with you or any of your friends during this past 12-month period?
Yes, through fellow social media posts and things of that nature.
He's attempted to contact you through social media posts?
No, meaning like posts like this where he says, you know, I once had you under my command and making
Where
like
he's talking
indirect-
about you?
Yes.
Okay, but he's not sent you a message or anything like that yet?
Yes, he has sent a text message. I received a text message just last month from an unknown number calling me a clown, which is things that he said before during the relationship when he was being verbally and physically abusive.
Okay, thank you. Go ahead.
Okay. I'd like to show you what has been marked as Petitions Exhibit 9 for identification. Has this document, Ms. Grant?
Yes, sir.
In the body of this, it says June 23rd, 2023, T-Mobile called me saying a male was trying to access my business account to purchase an iPhone 14. T-Mobile merged me in on the call and the man stated, Jaleesa, this is your enemy, and laughed. The person was able to access my message and T-Mobile one-time security code to verify, but the rep stated it felt weird and creepy, so she called me to ensure because the person was being irate and rude and rushing her, and she found it weird someone was trying to do this to her. Did you recognize that person as being Mr. Grant?
Yes, the voice that I heard sounded like Mr. Grant trying to access my account to make a purchase on T-Mobile.
I'd like to move the admission of Exhibit 9 into evidence, Your Honor.
All right, it's admitted.
You recognize this document, your Ms. Grant?
Yes, sir.
Whose number is 779-207-0084?
I don't know that number, but Mr. Grant has used different numbers before to try to contact me, or even throughout our relationship, he would use random numbers to text me if I would not respond to him, if I wasn't answering his calls. So these are things that he's constantly done.
And is this the same reference that he would call you as clown that's on this text?
Yes, sir.
Your Honor, I'd like to move the admission of Exhibit 10 in the evidence.
Okay, it's admitted.
So, Ms. Grant, Judge Davis has been overly fair with us and fair with you at the time that you first asked
And we can take
for
this down, Madam Clerk. Thank you.
a temporary order. Could you please explain to the court why you are seeking a permanent protective order? We understand that the court instructed Mr. Grant not to turn off or discontinue any utilities, and you said that he's done that. Could you explain any other reasons why the court should enter a permanent protective order on your behalf?
Yes, sir. Also just the indirect ways of contact, as well as my concern is Mr. Grant is ex-Special Force military and intelligence, which is how I think he's still getting, access to me or trying to contact me indirectly through sending Amazon packages, making subliminal posts, even when I change my number, contacting me through his ex-intelligence connections and ex-military connections, as well as Mr. Grant just has ways of taunting. That is just his tactic and method. He did that, even throughout the course of our relationship. And I'm still concerned for the safety of myself and my children with him doing these things, even with the current order in place, him canceling utilities, canceling the car insurance, and his indirect ways of contacting me.
Okay. What's the status of the divorce at this time?
It was just reassigned from Judge Johnson to another judge. We have an answer. We've sent our discovery. We have not received the discovery, so it's still in the early stages, Your Honor. We've even asked for a Rule 9 side on temporary alimony and child support. but we have not been given that date. And I understood that the court was closed down for some water damage some while ago. And so maybe that's why there was a backlog. But all we can do is file what we can file, and the court will give us the dates that they think and deem appropriate for us to have our day in court.
Okay. All right. Anything else?
Other than, it was good to see you again, Your Honor. I hope I didn't overtalk while you were
No,
talking.
it's okay. I'm taking this very seriously. I'm going to, what I'm going to do is look at the law, especially as it pertains to notice first before I see if I can address the other issues.
Yes, ma'am.
And I will, obviously, if I don't, the order is expired and you can refile TPO and or something in the divorce. If I do, it would have to involve a non-pro-tunc extension. And so I'm going to just look at the law piece by piece, and I'll issue an order by tomorrow because I don't want to leave things in flux too long. But I have a full calendar today, so I may not get to read everything I want to until I'm finished with my calendar today.
I am sure that you are an Evelyn Woods speed reader, Your Honor, and you'll get through everything that you need to get through. But thank you so much. You've always been fair with us, and I appreciate your time this morning.
All right. Thank you all. You're excused.
Thank you, Your Honor. Have a great day.
You too.